Welcome to Martinez Immigration Law. I'm Andrea Martinez. Thank you for joining us for this Know Your Rights info session. I want to introduce you first to our excellent staff, including our newest immigration attorney, Megan Galicia, legal assistant, Karina Kelly, and Helen Moreno, who is our office administrator. We as a team work together to serve you with excellence and make sure that immigrants are defended and empowered. We're doing this informational session today not to instill fear, but to instead train and empower immigrants with the knowledge that they need to be able to live their lives in peace and prepare their families should an unfortunate event with immigration happen. I want to talk about immigration law policy updates because I know there have been a lot of questions about what's happened under the Trump administration. And although there have been a lot of changes, I want to first start with the good news. One of the best pieces of news that we were not expecting but pleasantly surprised to announce is that DACA, the Deferred Action for Childhood Arrivals program, is still alive and well. So for the young people who are eligible for the DACA program that were brought to the United States when they were under the age of 16 and meet the other requirements, you can still apply for DACA and you can renew your DACA. Executive actions that have taken place under the Obama administration are largely have been rescinded by the Trump administration, but we are still seeing the courts, the judicial courts win. And for example, travel bans that President Trump tried to implement have been knocked down or not allowed to continue by the courts. And so we are pleased to see different travel bans that the Trump administration attempted to implement that were not able to continue. Unfortunately, deportation priorities have changed, and now what we used to have under the Obama administration as a list of priorities for removal, we do not have that same list. So as a general rule, anyone who is in the United States in violation of immigration law is a priority for removal. However, we are still seeing in our local Kansas City field office and the Office of the Chief Counsel that some of the same priorities that were implemented under the Obama administration are still being treated as priorities under the Trump administration, including people who are national security risks, people with criminal history. So those are still in practice. We are seeing the highest priorities for removal. And if a person is a low priority for removal, we would still move forward with requesting administrative closure or prosecutorial discretion at the immigration court if a person is placed into removal proceedings. There were some expansions to expedited removal that the president has announced and has not yet issued notice for. But I think it's important for immigrants who have been in the United States for over 2 years to know that at any point, President Trump could issue notice expanding the expedited removal policies to a nationwide policy that anyone who has been in the United States for less than 2 years could be subject to expedited removal, which means that they may not be eligible for a hearing. And if that's the case, if a person has been in the United States for over 2 years, I think it's prudent, and we'll talk about this a little more later, it is prudent to carry proof of your presence in the United States for over 2 years in your glove box so that if you were stopped, for example, by a police officer, you could say and show that you've been in the United States for more than 2 years and are therefore you have a right to a hearing. Some important things that immigrants need to know, and many immigrants don't know about immigration law, include the U visa and the T visa. A U visa is for immigrants who have been victims of serious crime in the United States and who have reported the crime to law enforcement and assisted in the investigation of the crime. If you're an immigrant or if you know someone who has been the victim of a crime and who's assisted in the enforcement of that crime, they should get a copy of the police report and come meet with an immigration attorney to see if a U visa might be a protection from removal for that person. Also T visas for victims of trafficking, which could include not only sex trafficking but also labor trafficking for immigrants who have been victims of, for example, wage and hour violations that have been potentially victimized by employers who don't refuse to pay, and then if the immigrant requests payment, the employer threatens to call ICE or the deportation officials on the immigrant who is undocumented. That could qualify an immigrant potentially for a T visa as a victim of wage and hour violations and labor trafficking. A special note about work cards and employment authorization documents that has changed recently. We're on the topic of changes in immigration law and policy right now, and one change that immigrants should know is that the Department of Homeland Security used to have a 90-day required turnaround under the regulation where they would adjudicate an application for the employment authorization document or work card within 90 days. That regulation has been rescinded, is no longer valid, and now USCIS is taking up to 6 months to issue work cards. So if you have an employment authorization document and you need to renew that EAD, then you should file 6 months in advance of the expiration date of your current work card. So that's something important to note. Many people are concerned and they come to our office and they ask, what happens if I am caught by ICE? And in their minds, it is an immediate deportation. But for people who have never been in removal proceedings before, don't have an order of removal out against them, they have a right to, in most cases, they have a right to a hearing. And the deportation process can take years. So I want to just explain that for people who fear being caught and immediately removed from the United States, that is not generally the case. An immigrant who has been in the United States for more than 2 years, really at this point, really any immigrant who is not subject to expedite removal has a right to a hearing. That means that if a person is detained, then they are detained for a short period of time by ICE and determined to whether or not they're a national security risk or otherwise would pose a flight risk. If ICE decides to release the immigrant from detention, then that generally happens within a day or two, and the immigrant is released either on a bond or under with an ankle bracelet or with an order of recognizance, just a signature bond. And then the removal process starts. The immigrant will receive a mailed notice of a master calendar hearing to their home. That could take months, and then they can go to the first master calendar hearing alone. They, at the second master calendar hearing, would need to bring an attorney, and the attorney would inform the judge what relief the immigrant is applying for. And the immigration attorney at that point would request an individual hearing if relief is available for the immigrant. This could be a process that takes years, particularly before the individual hearing, because an individual hearing with some judges in the Kansas City area isn't even being scheduled till the end of 2019 or now probably 2020. So immigrants need to know that this is a long process, and if they're picked up by ICE, in most cases this is not something where they're just immediately removed, and I think that that's a fear that I wanted to dispel through this informational session. I also want to talk to immigrants about the rights that they have. Even if you're undocumented, you have some constitutional rights that you need to know about. So one thing that we have provided is a list of what you can do if ICE arrives at your home and what you can do if ICE arrives at your workplace. If ICE arrives at your home, the first and most important thing that I want to emphasize is that you have to require that ICE show a valid warrant to be able to come to your home. So in this PowerPoint presentation, we have on this slide what is a judicially issued warrant and what is not. A judicially issued warrant generally has the name of your state on it, whether it's the Western District of Missouri or a Missouri or Kansas state court. You should see the name of your state at the top of the warrant. Then you would need to look at the warrant to see if it has your name, your address on it, and that is signed by a judge. If you see a piece of paper that says warrant on it, but then it says U.S. Department of Homeland Security at the top, that is not a judicially issued warrant. And you'll see in our slide right now to the bottom right of your screen what is not a judicially issued warrant. So you need to make sure that you and you need to make sure not to open your door or allow ICE to come into your home if they do not have a judicially issued warrant that is signed by a judge and that has your name and your correct address on it. If it has someone else's name, if it's the wrong address, then it's not for you, and you can tell ICE to go away and come back with a warrant that is applicable to you. You should also get a chain lock. This is just a piece of advice that's very practical, but a chain lock would help you open the door enough to review a warrant, but not enough to have ICE be able to barge into your home. And if ICE officers did barge into your home and broke a chain lock, then defense attorneys would be able to use that as proof of a Fourth Amendment constitutional search and seizure violation coming into your home when they did not have permission to do so. So it is very important that you require ICE to meet its burden and not just let ICE officers in your home without the proper warrant. Now, if ICE does have a warrant, then that's a different story. You should, at that point, and you are required to comply with the judicially issued warrant if they have one. If that is the case, then you should go outside, in my opinion, through a different door or window, not the main door where the ICE officers are waiting, so that ICE cannot get in and see other people or other people's documents who might be in your home. So please protect the other members of your family or the other people living in that home by exiting the property through a different door and then turning yourself in or going to the ICE officers and talking to them outside of the home so that they can talk to and potentially detain just you and not all of the other members of that home. We've seen cases where other documents are seized during a search for one person and then other immigrants are prejudiced because their documents were also in that home. You do have the right to remain silent. And on this screen on the right side, you will see that we actually have in English and Spanish a card with language that is very important for you. If you choose to exercise your right to remain silent, then you need to tell the ICE officer that you are exercising that right. And you can either do so by saying, I'm exercising my right to remain silent, or by providing a card like this one that actually has it written that you are choosing to remain silent, and if you're detained, you want to contact your attorney immediately, and that you refuse to sign anything without the advice of your attorney. If you are detained in your home or if ICE comes to your home, then another thing I wanted to mention is that you may refuse to show identity documents to ICE. And in fact, that is a good idea because any identity document that's from your home country can be used against you to help ICE prove its burden that you are not in the United States lawfully and that you're actually from another country. So you do have the right to speak with a lawyer, and you should exercise that right if you are detained. And please make sure that if you are detained, that you do not sign anything that you do not understand. That is imperative. If there's a document that's placed before you while you're in ICE detention, it may be a stipulated order of removal where you are authorizing your own deportation from the United States. And if you have the right to a hearing, you should require that ICE give you that right and that they put you in removal proceedings and that you see a judge. And you should refuse to sign any stipulated order of removal if you have a right to a hearing. If ICE comes to your workplace, you have less protection, less rights, but you still have rights. If ICE comes to your workplace, they either need a valid search warrant or they need consent of your employer to enter the non-public areas of the space. So a warrant is not required, but consent by the employer is. Don't panic and don't run away. If ICE comes to your workplace, then it's important that you, if they ask you to stand in a group according to your immigration status, that you refuse to do so and you instead stand in another non-designated area that would not be admitting or denying your alienage in any way. It's important that you also tell the officer that you would like to exercise your right to remain silent and to consult with an attorney. You still have the right to remain silent and to speak with an attorney, even in cases of workplace raids or ICE coming to your workplace. What can you do to protect yourself? I know that these conversations can bring a lot of fear, but there's also some things that you can do to protect yourself. One is, please do not ever pay a notario or people without a law license to represent you. Please make sure that when you are retaining legal counsel, that they are not only an authorized attorney, but they're an attorney that is well versed in immigration law. Immigration law is extraordinarily complex, and it's important that you consult with someone who understands all of the aspects of immigration law that might affect your case. Please do not carry false documents on your person. If you use a fake Social Security or a fake permanent resident card or fake driver license, please do not carry proof of that on your person, because if you're detained, then those documents will also be obtained by ICE and used against you. Never lie to an ICE officer or any police officer about anything. Never claim to be a U.S. citizen, please, not on an I-9 form or any other. Don't use a fake U.S. birth certificate, fake U.S. passport. False claims to United States citizenship are one of the unpardonable sins in immigration law, and it is very difficult to get a waiver of any false claim to U.S. citizenship. So please never claim to be a U.S. citizen. Don't commit crimes or even traffic violations. Don't give ICE or police officers a reason to stop you. But if you are stopped, then please hire a criminal defense attorney that can represent you and make sure that you are represented in your criminal proceedings so that there's no warrant out for your arrest for criminal proceedings. So please also hire a criminal defense attorney who understands the immigration consequences of criminal convictions, because if you get bad advice from a criminal defense attorney, you may be placed in removal proceedings for a violation that could otherwise have been avoided. Do not return illegally after a deportation. I know this is harder said than done, but the laws against illegal re-entry have gotten much harsher. The penalties under the Trump administration for illegal re-entry are more jail time, more fines than they were before. And so please try not to illegally re-enter if you are removed. A couple things you can do that I highly recommend right now if you're not detained. Please get passports for your children now. It's much easier to get passports for your children while both parents are not detained or the primary parent who has custody of the children are not detained. If you're detained or if you're deported, it is much more difficult to get passports for your children. So do that now. Also, like I mentioned earlier, because of the potential expansion to the expedited removal guidelines, please carry proof of 2 years of your physical presence in the United States or more in your glove box. That could be tax returns paid in the United States, U.S. citizen children's birth certificates, but do not carry proof of your alienage in your glove box, so that if you are detained by ICE, you can immediately show them that you have a right to a hearing. That's important because of the potential that at any moment the Trump administration could issue the notice required to expand the expedited removal regulations to include anyone in the United States who's been in the United States for less than 2 years. We've had many questions about powers of attorney and family law. Many parents who are concerned about what happens to their children if they're deported, or what would happen to their children even if they're detained for a day or two and the child's at school, what then? We have an attorney, and we've got her name on the screen, Jessica Gregory, who we have used for many years and recommend for any family law power of attorney need you might have. We have template powers of attorney in English and Spanish she's provided to us that are in, both for the assets and for your children. So we have separate powers of attorney for these two different aspects of your life. However, the power of attorney does not replace a holistic family preparedness plan. The IRLC and other organizations that are immigrants' rights organizations have actually provided family preparedness plans that immigrants can use to prepare for the worst. And if they were detained, what would happen to their child? Is there a person who could pick them up from school? If there are health needs or medical issues the child has, then this family preparedness plan would help loved ones and people who you trust to be able to take care of your children in your absence for a short period of time. So it's my strong recommendation that you read through the family preparedness plan that we have prepared and that we will be showing some slides on as I'm talking, but the child care plan that and that important children's information and the emergency numbers and important contact information lists in the family preparedness plan, please fill those out. Please give those to people who you trust, or tell your family where those are located, so that if it's necessary, people can take action and get your children from school. The schools need to know who you have as authorized people to pick up your children from school, and if there's any health or medical issues your children have, then your other family members or people you trust that would be picking up your children need to know those things. So please read that child care plan, write down any instructions if your child has medical conditions, and decide who can care for your children if you are unable to. Please register your child in with your country's government, so that they are also registered, if they were born in the United States, with whatever country you were born in. And I want I want to end the conversation with just a few words of encouragement. We at Martinez Immigration Law pray for you every day. We care about you immensely, and we care about your well-being. We want you to know that we are here to defend you. We are here to help you navigate this complex and very scary immigration process. If you'd like to schedule a consultation with the Martinez Immigration Law lawyers, you can do that by calling 816-491-8105. Again, 816-491-8105. You can schedule a consultation just to find out more about what immigration relief might be available to you. Who knows? Maybe there's an immigration relief that you didn't even realize, like a U visa or a T visa or some other form of relief that we would be able to analyze during the course of a consultation. We would love to serve you, and we will always be honest with you about your case and your life, because we understand our own family members are immigrants, and we care deeply about immigrants, and we believe that God cares about immigrants too. So we do this because we believe that it is a calling, it's more than a job, and your life and your family matter to us. So thank you for choosing Martinez Immigration Law.